So United States District Court. A district court is a federal trial court. So again, this is not an appellate court. United States of America, that's the prosecution, versus Emmanuel Ayala, the defendant. And this is an order of that court. So presumably the defense petitioned the trial judge to dismiss the criminal charge against Ayala based on the prohibition of having a gun in a post office. And this is the trial judge's decision. That's what an order is. The United States indicted the defendant, a postal worker, for possessing a firearm in a federal facility in violation of 18 USC, that's U.S. Code, 930A, Section 930A. The defendant argues that statute is unconstitutional as applied to him because the historical record does not support a law banning firearms in post offices, as per Bruin. The judge cites Bruin here. Relying on dicta from earlier cases, the United States responds that the Second Amendment allows it to punish the bearing of arms inside any government building. But the Supreme Court has been clear. The government must point to historical principles that would permit it to prohibit firearms possession in post offices. Now, what is dicta? Dicta is commentary in a court decision that's not essential to the court's ultimate finding in the case. And that just happens. It's kind of happenstance comments that get included in the final opinion, but they are deemed to be dicta and not have precedential value if that language is not required to arrive at the final conclusion of that decision. And dicta it's kind of an insult to that portion of a decision, saying, hey, that's not something worth paying any attention to. So when this trial judge refers to what the prosecution is relying on as dicta, she's basically saying it's worthless right at the start. Let's see. The Supreme Court has been clear. The government must point to historical principles that would permit it to prohibit firearms possession in post offices. The United States fails to meet that burden. I don't know. I've lost my... Darn it. The United States fails to meet that burden. Thus, I dismiss the Section 930A charge because it violates the defendant's Second Amendment right to bear arms. Now we get to the background section of this decision. The defendant works for the U.S. Postal Service as a semi-truck driver hauling packages out of a facility located in Tampa. He possesses a Florida concealed carry permit and kept his firearm, a Smith & Wesson 9mm, concealed inside his fanny pack for self-defense while on the job. From time to time, he carried the firearm onto post office property when retrieving his semi-truck from work for extra protection on the short walk to and from the employee parking lot. On September 14th, 2022, the defendant wore his fanny pack with the gun inside as he walked from the employee parking lot through the metal turnstiles and into the post office. After he clocked in, 2 agents from the U.S. Postal Service's Office of Inspector General, that's the Postal Service's police department, basically, stopped him and tried to detain him. The defendant fled, but was eventually arrested by officers from the Tampa Police Department. A grand jury indicted him for violating 18 U.S.C. 930A by knowingly bringing a firearm into a federal facility and 18 U.S.C. 111 by forcibly resisting arrest. The defendant moves to dismiss both counts. First, he argues that 930A, the ban in post offices, as applied to an ordinary post office, violates the Second Amendment right to carry a firearm for self-defense. Second, he argues that 930A and its incorporated exceptions in 930D are vague and ambiguous in violation of the Fifth Amendment. Finally, he argues that he should not stand prosecution for violating Section 111 because he resisted an unlawful arrest under the common law and under the Fourth Amendment. After reviewing defendant's motion and the United States response, I directed further briefing on the Second Amendment question, so further argument by the parties. I outlined Bruin's analytical framework and explained that the U.S. response to the defendant's Second Amendment challenge was unhelpful in this task. That 2-paragraph response by the prosecution, how contemptuous, when what's being argued is an enumerated constitutional right. That 2-paragraph response lacked any searching analysis into the historical record to determine whether Section 930, as applied to defendant, complies with the Second Amendment. Thus, I granted both parties another opportunity to brief the issue. Was the court required to do that? No. The court could have made a ruling against the prosecution based on their contemptuous 2-paragraph response the first time around. But the court said, I'll give you, prosecution, another shot at it, another bite at the apple. That briefing is now complete, and this order is based on that additional argument. Section 2, legal standard. In a criminal case, a party may raise by pre-trial motion any defense, objection, or request that the court can determine without a trial on the merits. An issue may be resolved on a pre-trial motion if trial of the facts surrounding the commission of the alleged offense would be of no assistance in determining the validity of the defense. Section 3, analysis. This order resolves only the defendant's Second Amendment challenge. The sole relevant facts are that defendant carried a firearm into an ordinary post office, which neither party disputes. As a result, this issue presents a pure question of law, ripe for disposition. Because I conclude that count 1 must be dismissed on Second Amendment grounds, I need not consider the defendant's vagueness challenge. The defendant's challenge to count 2 cannot be resolved on a motion to dismiss because even if the defendant could have lawfully resisted arrest, the jury must resolve the contested factual issues surrounding his resistance. Subsection A, Second Amendment challenge. New York State Rifle and Pistol Association v. Bruin, 597 U.S. 1, 2022, requires the United States to present historical support for Section 930A's application to defendant, which it fails to do. Post offices have existed since the founding, as have threats to the safety of postal workers and the public entering those locations. Yet the historical record yields no distinctly similar historical regulation addressing those safety problems by regulating firearms in post offices. Bruin deems this absence strong evidence of the statute's unconstitutionality. Even if the lack of a distinctly similar historical regulation was not dispositive, the United States has offered no relevant historical analogs. Although not my burden, I, the judge, conduct a more robust historical inquiry and likewise uncover no tradition of relevantly similar firearms regulations. I then dispel 2 misapprehensions held by the parties. First, nothing in Supreme Court dicta establishes that the United States may ban firearms in all government buildings. Did I lose my audio, folks? Can someone say in the comment? Oh, now it's back. Was there a period when I was talking when the audio went out? Let me know in the comments. I then dispel 2 misapprehensions held by the parties. First, nothing in Supreme Court dicta establishes that the United States may ban firearms in all government buildings. Second, the scope of the Second Amendment right is a legal question, not a factual one, and I need not hold an evidentiary hearing to resolve it. Instead, the government bears the burden to identify historical evidence supporting its challenged regulation. Finally, I explain why the prosecution errs in arguing that its proprietorship of federal land and buildings excludes vast swatches of the country from the protection of the Second Amendment. Subsection 1. Thanks, guys, letting me know the audio is good. Subsection 1. Bruin's Second Amendment standard and 18 U.S.C. 930A. 930A is the gun ban in post offices. When a firearms regulation is challenged under the Second Amendment, the government must affirmatively prove that the challenged regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. If the Second Amendment's plain text covers an individual's conduct, then the Constitution presumptively protects that conduct. And the government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearms regulation. Regulations that sweep beyond our historical tradition flout the Second Amendment's unqualified command that the right of the people to keep and bear arms shall not be infringed. This historical test often requires a searching inquiry, but not always. When a general societal problem has persisted since the founding, the inquiry is fairly straightforward. The lack of a distinctly similar historical regulation addressing the problem is relevant evidence that the challenged regulation is inconsistent with the Second Amendment. Likewise, if earlier generations addressed the societal problem, but did so through materially different means, that is evidence that a modern regulation is unconstitutional. On the other hand, cases that implicate unprecedented societal concerns or dramatic technological changes require courts to consider how and why historical regulations burden a law-abiding citizen's right to armed self-defense. Stated differently, addressing regulations that were unimaginable at the founding will often involve reasoning by analogy, a commonplace task for any lawyer or judge. This latter approach, which requires the government to identify a well-established and representative historical analog, has caused some confusion. To be clear, that inquiry requires a historical example that is relevantly similar to the challenged regulation, not a historical twin. When the government's proffered examples are not directly on point, courts must distill the underlying legal principles from the historical record. In other words, I, the trial judge, must determine whether modern and historical regulations impose a comparable burden on the right of armed self-defense and whether that burden is comparably justified. With that Bruin test in mind, I turn to 930A, which provides that, except as provided in a different section, whoever knowingly possesses or causes to be present a firearm or other dangerous weapon in a federal facility or attempts to do so shall be fined under this title or imprisoned not more than 1 year or both. A federal facility is a building or part thereof owned or leased by the federal government where federal employees are regularly present for the purpose of performing their official duties. Possessing a firearm in a federal facility is an activity that falls within the plain text of the Second Amendment. Thus, the United States must show that a ban on firearms in ordinary post offices is consistent with our nation's founding era tradition of firearms regulation. Subsection 2, Section 930A's application to post offices has no historical support. The United States concedes that there is no evidence of firearms being prohibited at post offices specifically, or of postal workers being prohibited from carrying them at the time of the founding. Despite the opportunity to present supplemental briefing, the United States fails to point to sufficient historical evidence supporting 930A's application here. Subsection I, the historical record yields no distinctly similar historical regulation addressing a problem that has persisted since the founding. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them. To decide the constitutionality of this federal statute, then, I must ascertain the scope of the Second Amendment right against the federal government in 1791. As explained earlier, if a general societal problem has persisted since the founding, the lack of a distinctly similar historical regulation addressing the problem is relevant evidence that the challenged regulation is inconsistent with the Second Amendment. And if earlier generations addressed the societal problem, but did so through materially different means, that too is relevant evidence that a modern regulation is unconstitutional. Here, any potential societal problem that 930A might seek to remedy have persisted since the founding. Although the United States does not explain a specific reason for banning firearms in federal facilities, 930A could reasonably be understood to target one of three problems. First, Congress might have sought to promote public safety generally. Of course, if the United States' purpose amounts to a policy disagreement about the virtue of the right to bear arms, the Constitution forecloses that as an impermissible basis to regulate. And even if a proper purpose exists, it still remains unclear why restricting firearms in government buildings rather than private buildings or public spaces generally would uniquely promote public safety. Public safety concerns were not unknown to the founders. Yet such concerns were not addressed through sweeping bans on firearms possession, just the opposite. A second concern might be some combination of postal employee safety, ensuring the efficacy of mail delivery. Again, those concerns pose no new problems. Post offices have existed since before the founding. The British ran postal lines up through the Revolution, and the colonies started their own competing system for intercolonial mail service when they declared independence. Of course, the Constitution gave Congress authority to create more post offices, which it did. Since the post office's creation, mail carriers have faced the risk of violence. Passengers of 19th century stagecoaches, which carried mail, risked death or injury if coaches were attacked by robbers or Indians. Recognizing this reality, Congress in the first half of the 19th century appropriated money to reward individuals who helped apprehend postal robbers. In the latter half of the 19th century, when locomotive became the dominant way to move mail, bandits threatened postal workers aboard trains. Yet the federal government never sought to ban firearms to protect employees or secure mail delivery. In fact, when mail train robbers became a growing threat in the early 20th century, the Postmaster General armed railway mail clerks with government-issued pistols from World War I. Although the general societal problems of violence directed towards postal employees and threats to mail delivery have persisted since at least the founding, there is a lack of a distinctly similar historical regulation addressing that problem. As the United States acknowledges, the first prohibition on firearms possession in government buildings was not codified until 1964. And the first regulation specifically banning arms on post office property was codified in 1972. Section 930 itself was not enacted until late 1988, a mere 35 years ago. The final potential concern that Section 930 might address is intimidation during official government proceedings. This generalized concern was known at the founding, as evidenced by a handful of founding-era anti-intimidation laws banning firearms during specific times and at specific places. Yet there is no evidence that Congress ever sought to address intimidation at post offices with firearms bans. And as I explain in the next subsection, the legal principles supporting those few anti-intimidation laws do not apply to post offices in any relevant sense. In short, post offices do not resemble the narrow classes of government buildings that were, at times, firearms-free zones at the founding. They're probably thinking here of like courtrooms, right, where arguments happen. All of the societal problems identified above have either persisted since the founding without being regulated by means of broad firearm prohibitions or are inapplicable to ordinary post offices like the one here. Even according to the United States, the first firearm prohibitions in relevantly similar federal buildings did not appear until the mid-20th century. Start again. Even according to the United States, the first firearms prohibitions in relevantly similar federal buildings did not appear until the mid-20th century, over 170 years after the founding. That fact is relevant evidence that Section 930A is inconsistent with the Second Amendment as applied to the defendant. Indeed, Bruin classifies this scenario as fairly straightforward. Subsection 2I. There is no relevantly similar historical analog to Section 930 as applied to post offices. The United States does not contend that 930A addresses unprecedented societal concerns or dramatic technological changes requiring comparison to a well-established and representative historical analog, nor could it, as the government attempts to address age-old problems through a new and near-complete firearms ban. But even if Bruin contemplated that old problems might be constitutionally addressed through novel regulations, the United States fails to identify any relevantly similar analog, and my own research uncovers none. Thus, the United States fails to carry its burden under Bruin to identify a historical tradition from the founding that supports the application of Section 930A to an ordinary post office. The United States argues that some founding-era laws prohibited arms in legislatures, polling places, and courthouses. As the Supreme Court has explained, there were relatively few such laws. Let's see. And the United States singles out only one example, a Delaware law banning arms at polling places before the founding, and then cites scholarship that refers to other examples, such as a pair of Maryland laws that prohibited arms while the legislature was in session. After offering this scattering or smattering of evidence, the United States proposes that prohibitions on carrying arms into centers of government deliberation existed at the founding. The United States concludes by baldly proclaiming that post offices and other government buildings are at a minimum analogous. This unreasoned comparison fails. First, not every government building, certainly not ordinary post offices, constitutes a center of government deliberations. Second, the United States does not explain how or why Section 938 burdens a law-abiding citizen's right to armed self-defense in the same manner as laws prohibiting possession in legislative bodies, polling places, or courthouses, nor could it. The United States historical examples are not relevantly similar to 930A in several important ways. For example, 930A completely forbids possession in most government buildings. By contrast, the Maryland Legislative Assembly bans applied only when the legislature was in session. And the Delaware election law governed polling places only on election day. These regulations contained meaningful time and place constraints. They were not perpetual exceptions to the right to bear arms. Finally, even if 930A were analogous to these statutes, I doubt that so few regulations could suffice to show a tradition. Although I am not, the trial judge, obliged to sift the historical materials for evidence to sustain the U.S. statute, I do so here. Unlike the plethora of post-Bruen challenges to 18 U.S.C. Section 922, this case presents a unique sensitive places challenge to 930A that could have broader implications. So a thorough historical inquiry might inform future challenges. In other words, she's doing this for other judges. She did all this research like it was a law review paper so that other judges could make use of it. Excuse me. To articulate the legal principles that underlie the Second Amendment, I begin by looking to English common law. After all, the Second Amendment codifies a pre-existing right inherited from our English ancestors. And because the founding era colonies and states were similarly codifying natural and customary law rights, their understanding of the right to bear arms is particularly informative about the scope of the Second Amendment protections. Together, this evidence illustrates several legal principles, but none justify the application of 930A to defendant. Subsection A, the Statute of Northampton and state copycats. The earliest potential analog is the English Statute of Northampton, enacted around 1328. The statute provided, "No man, great nor small, of what condition soever he be, except the king's servants in his presence, and his ministers in executing of the king's precepts or of their office, and such as be in their company assisting them, and also upon a cry made for arms to keep the peace, and the same in such places where such acts happen, be so hardy to come before the king's justices or other of the king's ministers doing their office with force and arms, nor bring no force in a fray of the peace, nor go, nor ride armed by night, nor by day, in fairs, markets, nor in the presence of the justices or other ministers, nor in no part elsewhere, upon pain to forfeit their armor to the king and their bodies to prison at the king's pleasure." Bruen discounts the latter half of the statute, the ban on going or riding armed, because later English law, such as Sir John Knight's case, interpreted that provision to apply only to going armed to terrify the king's subjects. Unlike the provision interpreted in Sir John Knight's case, the clause of the Statute of Northampton banning Englishmen from coming before the king's justices or other of the king's ministers doing their office with force and arms does not appear to have attached the same terror requirement. With this limitation of the terror requirement in mind, the Statute of Northampton remains relevant in informing the historical tradition of firearms regulation. 3 states, and possibly the District of Columbia, enacted near duplicates of the Statute of Northampton around the founding, and each included a version of this provision. First, but neither the Statute of Northampton nor its copycats helped the United States justify applying Section 930A to defendant. First, some copycats exclusively applied to judicial officers, and thus extended only as far as bans in courthouses. For example, the Virginia statute applies only to ministers of justice. And the draft District of Columbia statute refers to the justices or judges of any court within the district, or either of their ministers of justice, likewise focusing only on the judiciary. Thus, 2 of the 4 founding-era copycat statutes exclusively apply to bans on firearms possession at judicial proceedings. Their purpose is obvious: to avoid intimidation or interference in the orderly administration of justice. Next, the Statute of Northampton and its North Carolina copycat refer to the king's justices, as well as the king's ministers doing their offices. But I doubt the latter phrase encompasses ordinary postal employees. To start, a narrow reading comports best with the historical regulation's text and context. The statutes refer to the king's justices or other of the king's ministers, suggesting that the former is a subset of the latter, and that both are similar in level of importance. The statute also contrasts between the king's servants and the king's ministers, which implies that not everyone who worked for the king was one of the king's ministers. The list of officials authorized to execute the statute sheds further light on who qualified as one of the king's ministers. The king's justices in their presence, sheriffs, and other ministers of the king in their bailiwicks, lords of franchise, and the bailiffs in the same, and mayors and bailiffs of cities and boroughs within the same cities and boroughs, and borough holders, constables, and wardens of the peace within their wards. That's who could enforce this Old English law. Each of these officials appears to have possessed an adjudicative or law enforcement function, often as the king's representative within a certain area. Other historical evidence supports defining the king's ministers as high-ranking officials. One of the ordinances of 1311, for example, purported to allow Parliament to appoint King Edward II's ministers, defined as a list of high-ranking officials, including the Chancellor, the Chief Justices of the King's Bench, and the Treasurer. Likewise, the Statute of 1341 purported to hold any minister of the king to answer in the Parliament. The statute further attempted to require that the king's ministers swear to uphold Magna Carta by taking an oath in Parliament. The list of those required to be sworn, the Chancellor, Treasurer, Barons, and Chancellor of the Exchequer, the justices of the one bench and of the other, justices assigned to the country, steward and chamberlain of the king's house, keeper of the privy seal, treasurer of the wardrobe, controllers, and they that be chief deputed to abide nigh the king's son, Duke of Cornwall, is far narrower than the universe of everyone who worked for the king. Finally, a copycat from colonial Massachusetts referred to their majesties, justices, or other their officers or ministers during their office. This statute cannot carry the United States burden to prove a tradition of firearms bans in any building with federal employees. First, this statute, like the Virginia and District of Columbia copycats, might only extend to judicial officers. Second, the Supreme Court already explained that the Massachusetts statute merely codified the existing common law offense of bearing arms to terrorize the people, as had the Statute of Northampton itself. As discussed, although the Statute of Northampton's Ministers Clause does not appear to attach the same terror requirement as its public carry provision, neither did Northampton extend to every soul who performed a duty for the crown. Thus, absent Bruin and other countervailing historical evidence, reading officers to cover every government employee would come dangerously close to endorsing a de facto ban on public carry. The sensitive places exception cannot sweep so broadly. At most, the United States may be able to analogize to modern day equivalents of the listed officials from the Statute of Northampton, or to the specifically high-ranking officials sometimes referred to elsewhere in the statute of the realm as the king's ministers. Ordinary postal employees at an ordinary post office do not fit the bill. Again, it is the United States' burden to point to a relevantly similar historical analog in support of 930A's application to defendant. To do so, it must marshal the historical record and explain how and why the founders similarly burdened the right to bear arms. The United States does not point to the Statute of Northampton or any of its copycats, let alone address their meaning. At most, only 3 of the statutes appear to have extended beyond the context of judicial proceedings, and even those laws did not prohibit weapons everywhere that a government employee worked. Thus, I do not find them relevantly similar to 930A as applied to defendant.